and welcome to Legal Basics with Sarah Law Global. And my name is Tian. Now, when I was in school, I used to think the word consultant was very fancy. Like every time I would ask a person, "What do you do?" and they said, "I'm a consultant," my eyes would just light up because it was such a fancy thing. And today we're going to discuss independent consultancy, and then we're going to look at the employment issues within it. With us is a gentleman who is not new to the broadcast. I've probably been marketing him too much, so since he's not paying me, I'll let him market himself.
Well, thank you for having me. Viewers, my name is Anthony Leshan. I'm an advocate of the High Court of Kenya. I practice law at the law firm of CMS Dali Inamdar Advocates.
Ivy League.
Thank you for having us.
Karibu. Mr. Leshan, maybe you could define for us, what is an independent consultancy?
Okay. So generally you can provide work or your labor under different footings, okay? You can provide your work as an employee, okay? And you can provide your work as an independent contractor, okay? So those are two different classifications, okay? So I think the best way to understand it is to give a distinction between the two. When you're providing your work as an employee, you're providing your services to your employer in exchange for a remuneration. And most critically, you are agreeing to be subject to the control of the employer. Okay. So the employer will normally be able to determine or control where you work from, okay, when you do this work, how you go about it, okay. So there's a substantial degree of control in the case of an employer-employee relationship. Now, in the case of independent contractors, there's no employer-employee relationship there. And there are normally a number of factors that we look at to determine whether a person is an independent contractor or an employee, okay? So for independent contractor, the definition, essentially you look at a number of aspects that are not there in an employer-employee relationship. So it's a definition by exclusion, almost, okay? So for instance, in an independent contractor relationship, the extent of control is not as much as the extent of control in an employer-employee relationship. Okay, so independent contractors are not necessarily, they're not told where to work. It's up to them to determine the location. Okay, it's up to them to determine when to work. Okay, what time,
So long as they observe deadlines.
Yeah, I mean, they don't even have to observe deadlines. I'll give you the example of people who sell insurance agents, okay? So there's the insurer. The insurer is in the business of providing insurance to people, okay? So there's normally an insurance policy that the parties enter into. So people will normally become aware of these insurance policies through an agent, okay? So the agent will be paid a commission depending on the number of policies they sell or the value of the policy. So the only time you get paid is if you manage to convince someone to buy insurance
policy.
Okay. If you're too busy and you're handling other things, not a problem. No one will.
Nobody will say, "How come you've not sold this week?"
Really, okay, because you're an independent contractor. You determine, this week I'm not working. I'm not selling anything. I'll do that on Sunday. Okay. I can go to Westlands to do it from there. I can do it from Embakasi or wherever. So you determine the location, you determine the time, you determine how you go about it. Okay?
Does the time of engagement matter between the person that gives the work and the person that does it?
No.
Not at all.
Not at all. So that's one element, extent of control. Another element that we look for is the prospect of profit or risk of loss. When an insurance agent is doing his work or her work of looking for people to buy insurance, they spend their own money in terms of transport to go to where these people are.
Yeah.
Okay, spend their own money calling people.
They invest.
They invest
Yeah.
their own money and in covering
And
expenses.
yeah.
Okay. But the people they go to speak to may not necessarily take up the insurance.
Sure.
Okay.
Yeah.
So there, you've gone at a loss. Okay. As an
okay.
individual, the insurance will not compensate you.
Yeah.
So there's risk of loss. But there's also risk of, prospect of profit. If you get...
Yeah, then you get to cover your expenses and make a profit.
In an employment situation, as an employee, there's no risk of loss on your part. You're paid a fixed salary. Whether or not the business does well or not, you expect a fixed salary. Sure. Okay. Then there's the issue of provision of equipment. As employees, you'd go to an office. Employers provided you with an office. Okay. They've probably given you a computer, printer, a phone if you need to contact people. They've provided all the equipment that you need in an employment situation. Yeah. Independent contractors, most of the time they use their own
equipment and their own resources.
Okay, so that's another aspect we look at. Issues of also taxes. What kind of taxes? You see, employees get a salary, fixed salary. Yeah. And depending on, the threshold, you get deducted
from your salary.
Income tax, pay as you earn. Okay. For independent contractors, they normally get what we call a fee or sometimes a commission. Okay. So from there, the kind of tax that is deducted
is different.
Is different. Withholding tax at a different percent. So even that is an aspect that we look for.
Okay.
Most times you will find that people at the point of signing a contract, the contract sets out the rights and obligations of the parties.
Yes.
When looking at that contract, you might get the impression that, look, this is a very clear-cut case of an employment contract or a clear-cut case of
an independent consultant.
But then their conduct after signing
can
deviate completely from
either.
From what is written down.
Yes.
Okay. Yeah. Which can sort of change the classification of that contract. Okay. So when we are engaging in this exercise of classifying a contract, we have to look at what rights and obligations are set out on paper and what is the conduct of the parties thereafter. Okay. Okay. That way we're able to determine what kind of contract this is, where to classify it. And maybe a segue to that is, once this classification is very important. Yeah. It's very critical and it's a conclusion of law.
Yeah.
Okay.
So once we've decided it's either, then you can attach rights and obligations.
Yeah. I mean, what I mean by saying it's a conclusion of law is that you can write whatever you want on the contract. You can say expressly, this is an independent consultancy. Yeah. Okay. But if the matter goes to court, the court has a right to look at
and say, the way you've been operating, this is actually an employment
contract. Yeah. So it's a conclusion of law based on the nature of rights and obligations flowing between the parties.
Okay.
Yes.
Now, some employment contracts have a clause that says that you're not allowed to work for another employer, right?
Yes.
Or you're not allowed to carry out another business in the course of this employment.
Yes.
Now, would that particular clause in an employment contract, if you were to transfer it in an independent consultancy, where an employer says, well, we're giving you so much business, so we think you should work for us alone. Yeah. Do you think this is one of the things that can convert an independent consultancy to now be considered an employment?
Yeah, you see, those two instances you've given go into that header we call control. Yes. What is the extent of control that you have over a person? Okay. So control is just one of a number of things that we look for in classifying a contract. Yeah. So yes, it's a very important thing that can tilt the classification from
this to the other.
Yeah, exactly. So it can work that way. You can do that. You can have that effect.
I think actually I read a case like that. As you say, it's very it's a very tricky line. You have
Yeah.
to be very clear about it. This is on page 42 of Kashindi Digest,
Yeah.
and where the court was trying to clarify the difference between a contract of service
Yeah.
and a contract for services. A contract of service is the employment,
Yes.
and a contract for services is now the independent
contractor,
consultancy.
Yeah.
And it says that an employee and a contract of service is solely employed by a particular employer for a fixed period or contracted, as the case may be. It is also permitted to engage a person under a contract of service that may be oral or written with specific terms, but such an employee is not specifically under the control of the employer, as you said, and can be engaged by various employers at the same time as his contract to render a set service.
Yeah.
So if in that situation this person is allowed to take instructions from employer 1, employer 2, employer 3,
Yeah.
or this insurance agent, as you say,
Yeah.
if they can sell to you Britam and sell to you APA and any other, then that would make them an independent consultant. It would be one of the factors
that tends to suggest independent consultancy. And this classification is really important because it tells us what kind of claims can you make, upon termination of the contract. What kind of claims can be made? Where should you take these claims? Which court should you go to? What kind of remedies can that court give?
All right.
We've seen so many cases of people who are really independent consultants or contractors who come to the Employment and Labor Relations Court. And the court is not able to grant them any remedy
because they should have gone to a commercial court.
And also the kind of claims they can make. You see, the Employment Act, for instance, provides minimum rights that employees are entitled to. Things like leave days, protection of wages, procedure, of termination. So those are minimum rights that employees enjoy. But if you're not an employee, you're an independent contractor.
You don't get to claim them.
You really can't come to court and say, hey, I was entitled to
leave days for those 5 years.
So unless
the court decides that through the conduct,
your contract
it's an employee. It's an employee.
So very important to get these classifications right.
So now, as an employer who is contracting an independent consultant, and maybe it has gotten to a point where they want to terminate their services, what is the right procedure to terminate an independent consultant?
So the procedure would normally be set out in the contract itself. Because the document that governs the relationship between the parties is the contract that they have signed between them. So the process that is set out in the Employment Act does not apply to you.
As an independent consultant.
So the procedure, if any, that should be followed is what is set out in your particular contract. So if your contract says there should be some element of negotiations or discussions before, that's the process that you follow. It's entirely up to you as the parties to the independent contractor contract to determine for yourselves the process that will be followed.
All right. So it's just like any other commercial agreement.
Yes.
There's no due process at you. You've not been selling our insurance, so now we have to take you through disciplinary. No such thing.
Although I've seen some independent contractor contracts, which have incorporated those procedures. I've seen them. And that's why I started by saying some of these concepts have become very,
blood, mixed up.
Because people sometimes do not really get the distinctions between these two kinds of contracts. So they import things.
They borrow something from here and something from there.
Which is permissible because you're allowed to, enter into a contract.
The way you want, on terms
freedom
to contract.
Exactly.
Wow, I think we've all learned so much in this broadcast. If the viewers have any questions towards this topic, which is, I think, new for many people, how do they reach you?
Well, we are reachable. I think what we'll do, we'll have a link with our contact information,
All right.
CMS Dali Namdar Advocates. You can come to our Nairobi office if you wish to. We have a Mombasa office if it's closer to you. We are reachable on phone, email. We'll provide all that information, I think, for the viewers to be able to access us.
I think we also need an office in Kajiado. I mean, I don't feel represented. I still pitch for Kajiado.
Yeah.
Please have an office in Kajiado. I mean, even Kajiado has employment issues.
A lot.
Yeah. All right, viewers, thank you so much for being with us. Thank you for watching, for subscribing, for sharing. This information is very useful. So if you know somebody that needs it, please share the link with them. If you have any questions for us, you can reach us through our email address, that is info@cyroglobal.com. info@cyroglobal.com. You can also reach us through our old Gmail address, that is cyroglobal@gmail.com. Before we close the broadcast, we would like to thank our videography crew. That's Moshiri Frames, that is responsible for all these great videos, and for J. Ojuma Advocates, who facilitated the shooting of season 2 of the Employment Law series. Keep it with us. Note to send all your questions, all your queries, your compliments, and all your suggestions. Bye-bye. See you.